Okay. So again, welcome back everybody to the Civics Project, and today's session focuses on impeachment. I'm Beth Ribet, the Director of Repair, and I'm really pleased to be joining you all to talk about this subject. I want to begin with a land acknowledgement and say that Repair acknowledges the Tongva people as the traditional land caretakers of Tovangar, the Los Angeles Basin and South Channel Islands, where we're logging in from. And we're grateful to have the opportunity to work for the Tarahatom, the indigenous peoples in this place. We pay our respects to Hanukvatam, the ancestors, Ahihiram, the elders, and Eohinkem, our relatives and relations, past, present, and emerging. So as noted, today's subject focuses on impeachment, which is the process of trying an elected official or an appointed official in the U.S. Congress for some sort of harm or crime against the state. So we're first going to learn a little bit about impeachment as it's laid out as an element of the U.S. Constitution, and we'll then talk a little bit more about the process of impeachment and a little bit about its history. So the initial language governing impeachment is laid out in Article 2 and Section 4 of the U.S. Constitution, and it's just one sentence, which reads as this: "The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors." There are a number of other relevant parts of the Constitution, and these include Article 1, Section 2, Clause 5, which grants the sole power to impeach someone to the House of Representatives. So nobody can initiate impeachment except for the House. Article 1, Section 3, Clause 7 provides what the sanctions are for someone who's been impeached and convicted by the Senate. And these sanctions are limited in the Constitution to removal from office and potentially, doesn't have to, but can be also a bar from holding future office. That's up to the Senate. And an impeachment proceeding does not preclude any other penalties. So for instance, someone who is subject to impeachment can also be separately criminally prosecuted, but that would not happen through the U.S. Congress. Article 2, Section 2, Clause 1 provides for the president's pardon power, but indicates that the president cannot pardon someone who has been impeached. So again, that section deals with the pardon power, but makes impeachment an area where it does not apply. The president cannot pardon a person who's been impeached from that impeachment. Article 2, Section 4 helps define which officials are subject to impeachment and what kinds of misconduct constitute impeachable behavior. Article 3 doesn't explicitly mention impeachment, but in Section 1 it says that federal judges should hold their seats during good behavior. And so it's commonly come to be understood as providing the case for judicial tenure and saying that judges who, the interpretation that judges who don't engage in good behavior should be subject to impeachment. And Article 3, Section 2, Clause 3 provides that trials, except in cases of impeachment, shall be by jury. So in other words, Article 3, Section 2 basically says that impeachment, or Article 3, Section 2, Clause 3, basically exempts impeachment from the rules about jury trials in the criminal justice system. So that's pretty much everything that the Constitution has to say about it. And before we talk more about this sort of mechanics or process of an impeachment, let's think a little bit about why impeachment. Where did this come from? So the simplest answer is that it was inherited from English, from British practice. In Britain, impeachment had been a past tool of the British Parliament. So they had targeted ministers and favorites of the crown, people who'd been appointed by a monarch, in order to try to limit the power of the monarchy. So impeachment was a practice of, England's equivalent of the legislature against England's equivalent of the executive branch, in this case, the monarchy. And so ultimately, the United States has decided to adopt that model, though it adapted it somewhat. And the second answer in terms of why was impeachment important in the conception of the founding fathers who were drafting the Constitution, because it was considered a vital aspect of the system of checks and balances. The executive branch, for instance, has a great deal of power and can influence the judicial branch through judicial appointments, can influence the legislative branch by, for instance, giving or withholding the presidential veto, and by giving and withholding appointments to executive offices. And so the basic idea was that in order to put a check on the executive branch, the possibility of impeachment needed to be present. And similarly, for the judicial branch, impeachment was considered very important in terms of ensuring that there would be some check on judges who, once appointed, there was no guidance in the Constitution about how long their appointments would be. The rules about federal judges serving for life came later. But the basic idea was that judges have a great deal of power and a certain degree of independence. And so there needed to be some check, for instance, to intervene if a judge was taking bribes or something similar. The history and debate in the Constitution about impeachment was initially a controversy over a couple points. One, some of the founding fathers thought that impeachment powers should actually go to the judicial branch, so it should be the courts that decided impeachment rather than the legislature. But ultimately, they did decide to follow the British model on this point, meaning they gave the power of impeachment to the U.S. Congress. One of the arguments, though, for vesting impeachment powers in the courts was the worry that Congress members would just be too susceptible to executive influence. A lot of Congress members might want appointments, for instance, to the presidential cabinet, and might be willing to change their vote or change their process in order to accommodate the executive branch. However, eventually they decided impeachment powers, as noted, should still rest with Congress. They also struggled about how to define impeachable offenses and what language to use. So initially, they introduced the term maladministration, administration with the letters M-A-L in front of it. So basically, poor, bad, or dysfunctioning administration. James Madison, one of the players in the Constitutional Congress, objected to this language on the grounds that it was too vague. And after that, George Mason introduced high crimes and misdemeanors, which stood and basically passed without debate and became the language in Article 2 of the Constitution. And it was a British term, and it basically meant crimes against the government. And the term high and high crimes and misdemeanors basically refers to the power of the official. So someone who is in high office and engages in a crime against the state, against the government, would then be understood as committing a high crime or misdemeanor. And the term high didn't necessarily mean high bar, meaning it didn't mean that this crime had to be very severe. And note the word misdemeanors in there. So conceivably, it could mean that relatively smaller offenses might be the subject of an impeachment, whether for a judge or president or other elected official or appointed official. So high crimes and misdemeanors basically loosely means a crime against the government by a civil officer. So the next piece of this that I want to discuss is the process of impeachment. How does it work? The process in the House of Representatives can start two ways. It can start with an impeachment resolution, which is introduced as a bill and contains the proposed language that representatives can vote on. Or it can start as a resolution authorizing an inquiry. So rather than just initiating the text of articles of impeachment, a member of the House could say, you know, we don't know if we should impeach or not, but we think that there should be an investigation. So it can start with an investigation, or it can just start with a resolution which members of the House would vote on in order to decide whether or not to proceed to impeach. And either way, that resolution will go to the House Judiciary Committee, and that's been in place since the early 19th century. Before then, there were other investigative bodies that the House, could create. But again, since the relatively early 20th century, I believe it was around 1813. I'm sorry, 18th century, 19th century, 1800s, not 20th century. So around 1813, I believe the House introduced the Judiciary Committee, and that then acquired province over deciding whether articles of impeachment should go to the full House. So this resolution goes to the Judiciary Committee. It investigates as needed. It decides whether to pursue articles of impeachment, and if so, that goes to the full House floor for a vote, and it can pass with a simple majority. So basically 50 plus 1 of the voting delegates or voting representatives can vote to pass articles of impeachment, 50% plus 1. And note that it's up to the Judiciary Committee to decide whether there is a reason to even vote. So for instance, Representative Marjorie Taylor Greene, who's been controversial in the U.S. media and politics recently, announced that she was introducing articles of impeachment against President Joe Biden. At least in the news clip that I witnessed, there was no explanation of what or why, and no reporting on what he could possibly have done that would be considered an impeachable offense. So the fact that she introduces such a resolution, which she can do as a sitting representative, doesn't mean that the House of Representatives would ever vote on it. It means she would introduce it. It would be sent to the House Judiciary Committee, and they would decide basically whether to take it seriously. And in this case, I would think that they would probably not, since, again, as far as I know, at least, President Biden has committed no impeachable offenses. If the articles of impeachment are passed by a simple majority, then the House, in practice today, selects what are called impeachment managers, who you've been hearing about this month, February of 2021, in the news relative to the second impeachment of Donald Trump. So members of the House are selected to function fairly similarly to a prosecution team. So they appear before the Senate and they prosecute the impeachment. Once impeachment articles of impeachment move to the Senate, a 2/3 majority is required for conviction. So in a 100-person Senate, given the current number of states represented each in the Senate, each having 2 senators, that would mean that a majority would constitute 67 senators. Senate members are the equivalent of a jury in an impeachment hearing, so they are sworn in, and their goal is essentially to judge what's before them. The powers that the Senate have in impeachment hearings are limited to only 2 in terms of penalties that might be imposed. The most common, right, if a person is found guilty of whatever crimes are alleged in their articles of impeachment, would be removal from office. And the second, which does not have to be imposed but can be by the Senate, is the prohibition against holding future office. Criminal prosecution can still happen through the courts distinctly, so being acquitted or convicted by the U.S. Senate in an impeachment hearing does not bear on criminal justice enforcement one way or the other. So I want to share a little bit about the history of impeachment in the United States. The first impeachment started to take place fairly early, and I'm going to talk about the first impeachment of a U.S. president, and that was of Andrew Johnson. So most of you are probably aware that President Lincoln was assassinated, and his vice president at the time was Andrew Johnson, who then acquired the presidency essentially as a consequence of President Lincoln's death. So Andrew Johnson was relatively sympathetic to the Confederacy. The Civil War had ended, and the Union Army, representing the U.S. state government, the U.S. national government, had won in 1865. So just to place this in time, it's 1865. Abraham Lincoln is dead. Andrew Johnson has inherited his office as the vice president, now president, but has not actually been elected to the presidency. And he is in the midst, along with the U.S. Congress, of deciding what the post-war, the Reconstruction reality looks like in the aftermath of the Civil War. And as noted, Andrew Johnson was relatively sympathetic to the Confederacy. So compared, for instance, to Congress, which was more eager to establish its dominance over the Confederate Army, Andrew Johnson wanted to make sure that the Confederacy retained some of its powers. And he wrote this. This is from, again, President Andrew Johnson in August of 1866, less than a year and a half after the end of the Civil War. This is what he writes and speaks publicly. This is one of his speeches. So far as the executive department of the government is concerned, the effort has been made to restore the Union, to heal the breach, to pour oil into the wounds which were consequent upon the struggle, and, to speak in common phrase, to prepare as the learned and wise physician would, a plaster healing in character and coextensive with the wound. We thought and we think that we had partially succeeded. But as the work progresses, as reconstruction seemed to be taking place, and the country was becoming reunited, we found a disturbing and marring element opposing us. In alluding to that element, I shall go no further than your convention and the distinguished gentleman who has delivered to me the report of its proceedings. I shall make no reference to it that I do not believe the time and the occasion justify. We have witnessed in one department of the government every endeavor to prevent the restoration of peace, harmony, and union. We have seen hanging upon the verge of the government, as it were, a body called, or which assumes to be, the Congress of the United States, while it in fact is a Congress of only a part of the states. We have seen this Congress pretend to be for the Union when its every step and act tended to perpetuate disunion and make a disruption of the states inevitable. We have seen Congress gradually encroach step by step upon constitutional rights and violate day after day and month after month fundamental principles of the government. We have seen a Congress that seemed to forget that there was a limit to the sphere and scope of legislation. We have seen a Congress in a minority assume to exercise power which, allowed to be consummated, would result in despotism or monarchy itself. So that's quite an indictment, and if everybody is following, and you may not be, and that's understandable, his 19th century language, what President Andrew Johnson appeared to be saying was that Congress was attempting to take too much power, right? His last phrase is that if Congress was allowed to continue, it would result in despotism or monarchy, that it was trying to basically become a dictatorial body. And again, what he was referencing in context at the time was Congress's response to the Confederacy during and after the Civil War. So his basic idea is Congress is running amok, they're trying to create conflict, and if they are allowed to continue, this will be tyranny. So the majority in Congress, which at the time was the Republican Party, and again, I want to remind folks or share with those who haven't been with us before, that we should not read the Republican and Democratic parties once they came into existence in the 19th century in the way that we would interpret them today in the 21st century. The Democratic Party tended to be more pro-slavery, and in contemporary terms, we would think of them back then as more right-wing. The Republican Party tended to be, relatively speaking, more moderate, sometimes a little bit more progressive, again in 19th century terms. So Johnson was opposed by the Republican majority in the US Congress at the time. And the Congress responded by finding ways to impeach him. And there were a few different articles of impeachment introduced against Andrew Johnson. And I'm just going to read an excerpt from one of them because it really speaks to and answers in part, and actually eventually quotes, the speech by Andrew Johnson, which I shared earlier. So this is how Congress responded. Article 10. That said, Andrew Johnson, President of the United States, unmindful of the high duties of his office and the dignity and proprieties thereof, and of the harmony and courtesies which ought to exist and be maintained between the executive and legislative branches of the government of the United States, designing and intending to set aside the rightful authority and powers of Congress, did attempt to bring into disgrace, ridicule, hatred, contempt, and reproach the Congress of the United States and the several branches thereof, to impair and destroy the regard and respect of all the good people of the United States for the Congress and legislative power thereof, which all officers of the government ought inviolably to preserve and maintain, and to excite the odium and resentment of all the good people of the United States against Congress and the laws by it duly and constitutionally enacted, and in pursuance of said design and intent, openly and publicly, and before diverse assemblages of the citizens of the United States convened in diverse parts thereof to meet and receive, said Andrew Johnson, as the Chief Magistrate of the United States, did on the 18th day of August in the year of our Lord, 1866, and on diverse other days and times, as well before as afterward, make and deliver with a loud voice certain intemperate, inflammatory, and scandalous harangues, and did therein utter loud threats and bitter menaces as well against Congress amid the cries, jeers, and laughter of the multitudes then assembled. And they then proceeded to read into evidence into the article quote into the article the speech that he had given, in which I read an excerpt of from August of 1866. So what can we take away from all this? Well, one of the things that we can see is that there's controversy about what constitutes a high crime and misdemeanor. But this very first presidential impeachment hearing in 1866 and after illustrated the fact that while there's not clarity about what is a crime against the government, impeachment in and of itself can embody a deep power struggle between the branches and between parties. So this particular impeachment, Johnson's speech, Article 10, in response of the articles of impeachment within the House of Representatives, captured struggle both between the Republican and Democratic parties at the time and between the executive and legislative branches. Another insight that we can take away from this history is that impeachment helps to make our collective reality, our public comprehension of crime and its meanings, and of wrongdoing and its meanings. Now, we have never had a president be convicted by the Senate in the United States. Johnson, as noted, was the first U.S. president to ever be impeached. It didn't happen again until Bill Clinton, who was impeached by the House but acquitted by the Senate, and then followed by the two impeachments of Donald Trump, who was in both instances impeached by the House but acquitted by the Senate. Now, other officers have been impeached over time, though not that many. So impeachments don't just target presidents. But one of the reasons why impeachment is seen as very significant is it is a declaration of what's wrong, what's unacceptable, what should be understood as a crime against the U.S. government. So I'm going to share a book recommendation for today, and that is by Brenda Wineapple. And the title of the book is The Impeachers, The Trial of Andrew Johnson and the Dream of a Just Nation. So for those who are interested in the history I've just shared, this is a good book to go with. Jacqueline has a question, which is how and who decided the percent required to impeach? The Constitutional Congress did. So it is written directly into the Constitution that the House of Representatives can do so, and that the Senate then can convict, but with a 2/3 majority. A lot of the rules and process were created later, but those powers to the House and Senate and that 2/3 majority were specifically created by the Constitutional Congress and enshrined in the Constitution. Let's see. So the last thing that I want to do during today's recorded session is to share our weekly trivia. So for those who are returning guests, you're familiar with our weekly civics trivia slides, and I'll share those with our Zoom audience. And we will proceed with our 3 trivia questions related to impeachment for today. So first, which of the following has never been a basement for impeachment of anyone in U.S. history? A, waging war against the U.S. government. B, nepotism. C, sexual assault. D, abuse of the contempt power, which would apply to judges. And so our Zoom audience can share answers in the chat. And again, those choices are waging war against the U.S. government, nepotism, sexual assault, and abuse of the contempt power. And the correct answer on this one is B, nepotism. There has been at least one impeachment hearing of a federal judge in past which charged favoritism, but never nepotism, never specifically appointing family members. And some folks may be surprised that sexual assault has been a basis for impeachment, but it was in this century in 2009, targeting a Texas district court judge who, as I recall, was in fact convicted and removed both on that charge and others. So second question, who presides over the Senate hearing of an impeached sitting president? Some of you may have heard this from recent news reporting during the second impeachment hearing of Donald Trump. So answer choice A is the Chief Justice of the Supreme Court, B is the House Majority Leader, C is the Senate Majority Leader, and D is none of the above. So Chief Justice, House Majority Leader, Senate Majority Leader, or none of these. And the right answer on this one is the Chief Justice of the Supreme Court, but note that that applies to a sitting president. So Chief Justice John J. Roberts, the current Chief Justice of the U.S. Supreme Court, did not preside over the impeachment hearing of Donald Trump in the Senate because he was no longer the sitting president at the time. If the impeachment hearing had taken place in the Senate before he left office, then Chief Justice Roberts would have needed to preside. 3. Who is the first person to ever be impeached in the United States? A, Supreme Court Justice Samuel Chase. B, Judge John Pickering from the District of New Hampshire. C, President Andrew Johnson, who we heard about before. And D, Senator William Blount of Tennessee. So Supreme Court Justice Samuel Chase, Judge John Pickering, President Andrew Johnson, or Senator William Blount. And the correct answer is Senator William Blount, and he was the only member of Congress to ever be impeached in the United States, because before he could be ultimately tried or convicted in the Senate, he was expelled from the Senate using a different provision of the Constitution and different legislation. And at that point, Congress decided that sitting Congress people could not in future be impeached because as elected officers, they should not be understood as fitting the constitutional definition of a civil officer. And this was kind of an arbitrary decision, but this is what Congress decided, that elected officers who, other than the president and the vice president who are explicitly named in the Constitution, should not be impeachable, but they could still be removed through an expulsion process, which was successfully used against Senator William Blount. Now, of the other choices, as you know, President Andrew Johnson was the first U.S. president to be impeached. Judge John Pickering was the first judge to ever be impeached. Supreme Court Justice Samuel Chase was the only Supreme Court justice to ever be impeached, and he was acquitted. So I want to share some links for our Zoom audience to some useful places for more learning, and for our podcast audience, you can find histories and background and more about the process of impeachment through senate.gov on the web or through the house.gov website, specifically history.house.gov. So I want to say thanks to everybody who's been listening into our podcast, and we'll stop recording now and I'll continue to have a conversation with our Zoom audience. But I do want to invite folks first to join us in March of 2021. We have planned episodes next weekend on the Electoral College, that's March 7th, on the federal budget, a really important subject in this economy, on March 14th. We have a special guest, Professor Hiroshi Motomura from the Center for Immigration Law and Policy at UCLA, who will be joining us on March 21st to talk about citizenship. And then we'll reconvene on March 28th to start to learn about state governments. And in addition, our monthly film screening will take place on March 31st, and we'll be screening the film Lake of Betrayal, which focuses on the Kinswa River Dam and the history of U.S. treaty violations, specifically against the Seneca peoples. And we will be joined by Dr. Mashana Goman, who is a member of the Tonawanda Band of Seneca, who will provide commentary after the film. So I hope many of you will join us for that on March 31st at 4 o'clock Pacific Time, 7 o'clock Eastern Time. And for those listening on podcast, this is all in 2021. And again, I want to thank everybody for listening in, and we will end recording and proceed to Q&A for our Zoom audience.